Hello friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the proposal on criminal justice reforms. We will see what are the proposals made by the Home Ministry at the central level in order to make amendments to the criminal justice, that is in the IPC and in the CrPC. What are the proposals of amendment proposed by the Home Ministry? We will be looking into it in detail. We will see what is the rationale behind such amendments. We will also see what are the proposals, and we will see what are the needs for caution, and we will see what are the principles that needs to be implemented, and we will also discuss about the shortfalls that needs to be addressed and what is the way forward or what has to be done. So these are the topics that we will discuss today. A very important lecture for your UPSC preparations. So you can expect a question from this topic in your mains examination in your GS paper 2 under polity and governance. So a very important topic. We'll try to cover all important aspects of this. Let us first start with the current affair. Let us see what is the current affair. So the Home Ministry at the central level is proposing certain amendments. So Home Ministry is planning to amend various sections of the IPC, that is the Indian Penal Code, and the CrPC, that is the Criminal Procedure Code, CrPC and IPC. So Home Ministry is trying to or planning to amend certain sections of IPC and CrPC, which are the criminal justice procedures available now. Now let us see what is the rationale of the Home Ministry, why it is planning to take up certain amendments, why or what is the reason. Now IPC or the Indian Penal Code, it was introduced by the British. So IPC was introduced in India by British in the year 1860. Now when British introduced IPC in India, the IPC was based on the spirit of master and servant. Now why this principle was adopted? This was because at the time of British rule, the policing or the police force was raised to protect the interest of the British. So British was considered as the masters and the citizens or the people in India, they were considered as the servants. So they introduced IPC with the principle or the spirit of master and servant in order to serve the British people or to protect the interest of the British. Now after independence, at present the duty of the police is to protect the people. Now the duty of police is to protect its citizens or protect its people. So this is one reason. The change in the principle. Now the principle or the spirit has changed. Now we are citizens and therefore the duty of the police is to serve the people or the citizens. Now second reason is that in the existing codes of IPC and CrPC, especially in IPC, there is uneven punishment. Uneven punishment means for various crimes which are of similar nature, there is uneven punishment or the punishment is not the same. Now let us take an example. Snatching a chain or snatching a bag from the road. So this can be a life-threatening case in some cases. You have seen that some thieves have snatched the train, then finally murdered the person. So this can be life-threatening in certain cases. But the punishment is not commensurate with the gravity of the crime. So that is why we say that there is uneven punishment. So this is the second reason. Now the third reason is that after the IPC was framed, it was never amended in totality. That means we have seen that in 1860 the IPC was formed, and since 1860 IPC was never amended in totality, that is altogether or in total. It was amended but not in total. Only certain additions were made or certain deletions were made. That is, certain additions and deductions were made out of IPC, but not in total. It was amended even once since its formation. So considering all these reasons, it is very important in order to standardize the punishment and align these punishments to the present needs. This IPC was formed in the year 1860. The nature of offences or the nature of crimes have changed. So it is important to standardize the punishments as well as to align the punishments according to the present needs. And the key idea behind this amendment is to change the spirit of the master servant to that of citizens. So the purpose of policing is to serve the interest of the people. So the spirit of policing or the spirit of this IPC has to be changed. So these are the reasons why the government is considering an amendment to the IPC and CrPC. Now let us see what are the proposals of the government. According to the Home Ministry recently said that the Bureau of Police Research and Development should work on the proposal to amend the codes. So it is a responsibility of the Bureau of Police Research and Development to work on the proposal to amend the codes, that is the IPC and CrPC, Indian Penal Code and Criminal Procedure Code. The ministry, that is the Home Ministry, has written to different states and union territories for seeking the opinion of the union territories and states, the suggestions. So to seek the suggestions and opinion from different states and union territories, the ministry has already written to the states and union territories. And also 2 committees are set up. 2 committees comprising of legal luminaries have also been constituted by the Home Ministry to give suggestions regarding the amendment of CrPC and IPC. So these are the proposals of the government. And let us see why there is a need for caution, why we need to be very careful in amending this CrPC and IPC. Now, it is very important that we need the revision of the codes. We have seen what is the rationale behind changing the codes. So when we analyze the rationale or the need for changing the laws or the codes, we find it that it is very important to revise the codes. But it should be done in a very careful manner. That is, it should be principled and guided amendments. It should not be unprincipled or unguided amendments. Now, why there is a need for caution? The need for caution is because the criminal law is considered to be an apparent expression of the relationship between the state and its citizens. So it defines the relationship between the states and its citizens. So the principles have to be kept in mind while making an amendment to this criminal laws of IPC and the CrPC. So that is why we need to be very careful, and let us see what are the principles that needs to be considered while making the amendments. Let us first see what are the principles needed for the victims. So with regard to the victims, the rights of the victims, the rights of the crime victims needs to be protected. So in this regard, victimological underpinnings should be given an importance. What is meant by victimological underpinnings? Victimological means the theory of understanding the psychology of the victims. So the mindset or the psychology of the victims should be understood and should be given a thrust or a focus. So this will help in protecting the rights of the crime victims. So in this regard, what can be done? Victim and witness protection schemes can be introduced. It's already in place. So victim protection schemes and witness protection schemes are important. Second one, the use of victim impact statements. Victim impact statements should be used. Third one, advent of victim advocacy. Fourth one, increased participation of the victims in the trial. So in the trial which is held in the courts, victims should have an increased role or participation, and this will help in fair conduct of the trial. Now fifth one is enhanced access of victims to compensation and also restitution. That is, they should be compensated and also they should be given protection or shelter during the time of the trial. So all these will help in protecting the rights of the victims. Now second one, principles needed for guiding the offences. So with regard to offences, what has to be considered? First of all, new offences should be constructed. This is because IPC was formed in the year 1860. So at present the nature of the crime or offences have changed a lot. So there is a need to construct new offences, and also secondly it is important also to rework on the existing classification of offences. So the existing classification need to be revised, and thirdly new type of punishments should be introduced. For example, community service orders, restitution orders. So these kinds of new type of punishments can also be introduced. So this is with regard to offences, and the third one is with regard to classification. We will see that the chapters of the IPC, they are overloaded at several places. So it needs a reclassification. So it is necessary to have a reclassification. For example, the offences like criminal conspiracy, sedition, offences against coins and stamps, etc. must be replaced or they should be abolished. Certain provisions are not required now. So those provisions that does not have a relevance, they can be abolished, and certain sections needs revision. So it has to be revised or replaced. And certain chapters like the offences against public servants, contempt of the authority, public tranquility, trespass, etc. should be redefined. Certain provisions needs a redefinition, so it can be redefined and also it can be narrowed down. Now new offences should be added. For example, Malimat committee has suggested new offences or to be added, new offences to be added. So such type of new offences, they can be added. Now let us see what are the shortfalls that needs to be addressed. First one, unprincipled criminalization must be avoided. What does it mean? Unprincipled criminalization means that criminalization without following any principles. It should be avoided. Why? What are the impacts of unprincipled criminalization? The first impact is that too many entrants or too many authorities will look into or come into the criminal justice system. So the criminal justice system should be based on certain principles, and these principles should clearly define the authority and power of each authority or each office. So this will help the state in fencing the criminal justice system to a particular department or to a particular authority. And also the unprincipled criminalization often leads to creation of new offences based on unscientific grounds. Now thirdly, also arbitrariness in the criminal justice system. So these things can be avoided if the criminalization is based on certain principles. So for that, guiding principles needs to be developed after sufficient debate before criminalizing an act as a crime. Now let us see what should happen in the procedural side. On the procedural side, sentencing reforms are important. What is meant by sentencing reforms? Sentence refers to the punishment or the verdict given by the court of law. So the court of law determines the punishment to be given to a criminal. So sentencing reform means that on what principles sentencing should be given, or on what principles the punishments should be given. So this is called sentencing reforms, and this is a very important reform from the procedural side. Why do we need procedural side reforms like the sentencing reforms? This is because at present the judges have the discretion to decide the quantum and the nature of the punishments or the sentences. So it is up to the judges, that is the judiciary, to decide what is the quantum of punishment and what should be the nature of punishment. And now, because this is a discretion of the judges, in most of the cases judges sentence convicts differently for crimes of same nature. That is, if the crime of same nature has been committed by different persons, different judges give different punishments. This is because it is upon the judge's discretion to decide the nature of punishments and the quantum of punishments. Now, if sentencing reforms are adopted, the judges will have to stick on to the theory of punishment. A particular theory of punishment will be provided and judges will have to stick on to it. So these are the shortfalls that needs to be addressed. And now Let us see what is the way forward, what has to be done. Firstly, we need to draft a very clear policy, and this policy should inform the changes that are envisaged in the IPC or the CrPC. So a clear policy should be put in place that will inform the citizens, the public, about the changes made in the IPC and CrPC. Secondly, simultaneously, improvements has to be made in different departments of the government. For example, the police department, the prosecution department, that is the advocates, the government's advocates are the advocates of the police. So again, in the judiciary, in the prisons. So these are all different departments associated with the criminal justice system in India. So in all these departments, reforms has to be undertaken, and only then changes in the IPC or CrPC will become effective. Now, thirdly, a criminal justice reform committee has to be formed, and this criminal justice reform committee should have the mandate to evolve a criminal justice policy. So a criminal justice policy has to be formed by this criminal justice reform committee, and the proposals of this committee should be a continuation of the work done by different past committees. For example, the Menon committee, which was formed for the criminal justice system. Also the Malimat committee. Malimat committee is a very, very important committee. Malimat committee, again the Law Commission recommendations. So this committee, the Criminal Justice Reform Committee, should take into consideration the previous recommendations of all these committees, and its work should be a continuation of the work done by the previous committees. So these are the steps required. You can find the PDF of this lecture on our website www.studyiq.com. You can also follow my Facebook page for more video updates. You can write to me at joyce.studyiq@gmail.com for any of your queries and clarification. Thank you.